Silence, court rise.
My lords, Mr. Toledano and I have had a discussion. I'm going to endeavour to finish my submissions on the appeal and also in relation to the respondent's notice by 5 to 4, I hope, possibly 4. And my learned friend will then have a good half an hour to respond. Thank you very much.
Yes.
Lord, I've probably slightly taken out of track, but I am dealing with the issue at this stage of whether Mr. Justice Teare's order comes within section 12.1. That's where we are dealing with. And the first point I want to make, I've got a number of points I would like to deal with. The first one is that enforcement proceedings in support of a foreign arbitration award, such as we are concerned with, constitute fresh court proceedings against the counterparty to those proceedings, and as a matter of principle they are no different to any other originating process brought against a counterparty. And in this case we are dealing obviously with a state as the counterparty. And
I don't think that point's in dispute, is it?
no, but section 12 apply, and I'm not sure if this is in dispute or not either, but section 12 applies to enforcement of arbitration award proceedings. And that, if it is in dispute, is made good by Mr. Justice Gross's decision in the Norsk Hydro case. And I think I'd like just to show your lordships that case very quickly, if I may. It is in tab 15 of the authorities bundle number 1. If your lordships wish me to explain what it's about, I will do so, but I was just going to jump in to show you a couple of extracts from the judgment, if I may. And first of all, at paragraph 7 of Mr. Justice Gross, as he then was, the decision, at page 563, and the relevant order we are dealing with, there were two orders in this case, as the Morrison order and the Smith order. The Morrison order was the order by which the arbitration award was being enforced, and the point I wanted to note at paragraph 7 is that little g, or g on the left hand column, you'll see there it's referred to, the Morrison order and associated judgment were served through diplomatic channels.
This is page 563, yeah.
563, my lord. So that
Opposite G. Oh, I see. Yes,
Yes.
Yes, thank you.
that's just making the point that in this case the claimant assumed that they had to serve the order through the FCO, as we say everybody should do in this sort of instance.
Probably not much difficulty in 2002 serving on Ukraine.
Well, my lord, yes, I won't engage on a debate about matters in Ukraine at this present stage. Then, my lord, if we go on to page 568, and it's paragraph 21 is where it starts, we are dealing here with what is the Smith order, and this was effectively the attachment order. This was enforcement proceedings being carried out on the back of the original Morrison order.
It was an attachment over funds held by Ukraine and Deutsche Bank.
Indeed, my lord, that's quite right.
Sorry, so just repeat that. The Smith order is what?
The Smith order,
Third party debt
Third
order.
party debt
Garnish order.
order. Oh, I see. Yes, thank you.
and this is where the issue of whether or not section 12 applied to this case, and it involved a consideration of, obviously, you see on page 569, his lordship sets out sections 1 and 2 of the State Immunity Act and section 22 He then deals with 6218 of the CPR, and then various matters in paragraph 24. And then if we pick it up at 25, please, at the very bottom of 569, he says, in my judgment, the Smith order was premature, cannot stand and must be set aside. My reasons are these. And there's quite an important point in number 1 I was going to deal with later, but I'll deal with it now, if I may. It says, number 1, CPR 6218 contemplates that an applicant seeking enforcement may proceed by way of an arbitration claim form, or may simply seek an order granting the relevant permission. Were Mr. Walker's argument, he's to the claimant, my lord, well-founded, it would be necessary either, 1, to read section 12.2 of the Act as not applying to such arbitration claim forms, or 2, to conclude that section 12.2 applied where the applicant proceeded by way of arbitration claim form, but not otherwise. Conclusion 2 was described by Mr. Phillips as bizarre, and it is sufficient to observe Mr. Walker did not contend for it. It follows that Mr. Walker's argument must and does proceed on the basis that section 12.2 is inapplicable to all enforcement procedures under CPR 6218, and that's the point he goes on to deal with. Now, the point, my lord, on the bizarre point is interesting for my submission, because what is being said, you will recall under 6218, the court can require the claim form to be required to be served, but it need not do so. Now, if the claim form is required to be served, section 12 necessarily is in play. But if the claim form is not required to be served and it's just the order, which we'll come to in a moment, then section 12, on my learned friend's argument, does not apply. And the submission being made in relation to that argument here by Mr. Guy Phillips was said, well, that's bizarre, that can't be right.
But it would be true, again, the point that I put to you earlier, the same argument, albeit perhaps not so starkly, might arise in relation to non-state defendants as well. That because the effect of 6218 is that unless the court orders service of the claim form, you don't have to serve it at all. If what you have to serve is the order, but you have difficulties in serving, then you get into 628. And assuming against you for the moment that 628 doesn't require the showing of exceptional circumstances, you get to a point where the issue as to whether or not service is dispensed with is different depending upon whether what's served is a claim form or whether what's served is another document.
Well,
and that's what the rules say.
Well, with respect, I think that's the next point that I'm going to come to, the power to dispense. At the moment, I'm deciding, does the need to serve the order require, or does it bring into play section 12 of the State Immunity Act? That's all I'm looking at. And the point I'm making is that it would be bizarre if section 12 applies in a case where the claim form, for whatever reason, is required to be served under 6218, but it doesn't apply if the claim form isn't required, but in its place you have the order being required to be served. And so this is at the threshold point of whether we're in section 12 or not, my lord, to be, and the point that's being made here is that the defendant counsel says, well, that's bizarre. The claimant's counsel says, well, he obviously thought it was wrong as well because he didn't even run with it. And Mr. Justice Gross has obviously regarded that as being correct. So that's power. I say that's powerful support for my submission, that it cannot be right that whether or not section 12 applies in the context of a 6218 enforcement procedure is dependent upon whether or not the claim form was actually required to be served or not. because it can't depend upon happenstance. Section 12 either applies to that provision or it doesn't. And we say, well, it plainly does.
One reason for requiring the claim form to be served in the case of a state might be to ensure that Section 12 did apply in circumstances where it otherwise wouldn't.
Well, that's the alternative point, my Lord, and it's why my learned friend, I think, a couple of times says, "Oh, well, this point's not taken by Mr. Davis because we don't need to, because we've got the judgment we require." But if necessary, I would say to your lordships that Justice Stanley Burton was right in the AIC case, where he said that the claim form in that case had to be issued and served. So there's an alternative that either, if Section 12 is applied, the court should, in every case involving a state, require the claim form to be served.
Sorry, who said that?
In every case in which an arbitration award is sought to be enforced against a state through Order 62, CPR 62/18, the court should either require the claimant to issue and serve the claim form on the state, or it is simply the order that fulfills that purpose. That's the point that his lordship, or Justice Mayles, was making in his judgment, that the practical reality is, well, if the claim form is required to be served, then that fulfills that purpose, but otherwise it's the order. But the alternative, my lord, is that in every case it should be that a claim form is served.
I'm afraid I'm stumped by the very first sentence because I'm rather behind on page 57.1. It says CPR 62.18 contemplates an applicant seeking enforcement may proceed by way of an arbitration claim form or may simply seek an order granting the relevant permission. But 62.18 says that you have to apply by way of a claim form.
Well, I don't think 62.18 says
It may be made, but without notice, in an arbitration claim form.
You have to issue the arbitration claim form.
it's under 62 Rule 3, I think, that says it is now. Well, the rules are such now. I'm not sure that that's what the.
Well, that's what I'm asking. I'm stumped at the first sentence, I'm afraid.
Yeah, it's very confusing. I agree with my lord. I mean, he can't actually be right what he says in 1,
That's why I can't
because you
understand the
always
rest of
have to proceed by way of an arbitration claim form. The issue is whether you have to serve it or not,
Exactly. So
which is
that's why
sub rule 2, which says that unless the court orders, you don't have to serve it, but you always have to have an arbitration claim form.
Well,
So the process is arbitration claim form.
the process is, but the issue is the interpretation of Section 12. We're dealing with the interpretation of Section 12 of the State Immunity Act. What does that mean in its context?
No, I understand your argument, absolutely. I'm trying to understand what the judge, Justice Gross, was saying. I mean, can you help me on this? Because I'm trying to understand what this means. Has he simply got it wrong? And if so, can we put it in the correct form? Is he saying that it contemplates an applicant seeking enforcement must proceed by way of an arbitration which may or may not be served? Is that what he's talking about? Otherwise, I don't understand. Maybe the rules are different. They were different then. I think they were the same.
Paragraph 23 significantly he omits number 2, but 62.18 seems to be in the same form as Mr. Toledano showed us.
Yes.
Well, I don't
I
understand.
don't think it's well.
Well, can you? Because
It
I
may
don't
be
understand
mistake-
this.
My lord, it may be mistaken to have said, as he has said, or may simply seek an order granting the relevant permission.
That's what I don't understand.
And I think it
Can I just ignore that and go on to the next sentence? Is that what you're telling me to do?
Your lordship can. I don't
All right,
think it
so
matters.
were Mr. Walker's argument well founded? Now, Mr. Walker is arguing what?
To the claimant, he is saying that enforcement proceedings under 62.18 do not fall within the State Immunity Act in Section 12.
I thought that isn't in dispute that they do, in principle.
It was here.
This is the argument about adjudicative jurisdiction as
Indeed.
against
Yes.
enforcement jurisdiction, which was
Yes.
blown out of the water
It is now.
in
yes.
this case and in one of the other cases. I
Yes.
forget which one now.
But
This-
this isn't relevant. We've
So it's
gone
not
beyond
relevant.
it. I don't understand
My
what the
lord, we've
relevance
gone
of
beyond
this
that, but the point is that
Sorry.
what he was saying is that there were two potential arguments open to him. One, and then this is where either one, to read section 12.2 of the Act as not applying to an arbitration claim form, or, which is the argument he runs and loses on, or to conclude that section 12.2 applied where the applicant proceeded by way of arbitration claim form, but not otherwise. That's the argument that is then said, well, that can't be right.
So we're to read this with my current understanding of what the rules are, with that those little twos, to conclude that section 12.2 applied where the applicant proceeded by way of an arbitration claim form required to be served,
Yeah.
but not otherwise.
Yes,
Right.
my lord, yes.
Right. Now I'm beginning to understand it.
And that leads me into the. but it's a bizarre proposition, is what was said there.
If that's what he means.
Yeah, assuming, well, even if he doesn't mean that, my lord, the point is still good that I make, that under 6218,
Yes.
you either have, if the claim form is required to be served, then
Into
section
section
12,
12 territory.
There's no difficulty.
Not otherwise.
but if not,
Yeah.
you're not. And all I'm saying is, well, that cannot be, there's no logic to that. Why should you have the safeguards that section 12 provides you with if the claim form is required to be served, but you don't if it's not?
And he goes on to hold, doesn't he, at 5, that insofar as it's in dispute, the wording in section 12, subsection 2 about entering an appearance applies to the time period within which the any application to set aside the order is to be made.
Indeed.
So this is really your policy argument. I think that's what it comes down to.
My
It's really a policy argument.
it is, my lord, yes.
This is your policy argument.
It is a.
That you say it's irrational to provide the protection of 12.1 if you're required to serve the claim form, but not otherwise.
Yes.
That's your policy.
It is. And it's whether it's very similar to your lordship's the point you put to my learned friend. Well, is it purposive against literal
Yes, yes.
interpretation?
Yes.
Yes. Then.
But that's what
And
but now just
but the other point I wanted to make here, my lords, is in sub 3 and 4, and it maybe I don't need to because it's already there. That there is no question that section 12 applies in the context of the enforcement procedure under 6218. That's the point he makes in 3 and 4 of paragraph 25.
So
And-
a third party debt application is a separate proceeding which is instituted by the form for third party debt claims and does have to be served. That's the conclusion of Mr. Justice Gross.
Yes.
Yes.
And the point that was made in that, in the Morrison order, sorry,
No,
the
it's
reach-
not.
sorry,
No, it's not. That's
sorry.
not what he decided.
No.
The point, as I understand it, is that they jumped the gun, hadn't they?
Yes.
They'd issued the third-party debt. They got the third-party debt order from Mr. Justice Andrew Smith
Yes.
about a month before the time for
Yeah,
the stay period in the Morrison order.
If,
Right.
just to show you in the head note, it's perhaps clear, or on the first page, it says the Morrison order, which was the original enforcement order, in the middle between E and F, Morrison J made the order sought as against those 3 named respondents. The order included provision giving the respondents 21 days from service of the order to apply to set it aside. Now that was the problem. He only gave 21 days And the point was that under section 12.2 of the State Immunity Act, you have to give 2 months from date of receipt of the relevant document. That was the point. And he jumped
So it's
the
the
gun.
point he makes, it's the point what Mr Justice Gross makes in paragraph 25(6), isn't it? So you
Yes.
have to add 2 months to the 21 days and you get to the 15th of October.
Yeah, the point that I do understand, like so much else, is in 5, he comes to the conclusion that the time, that the 12.2 provision, time for entering an appearance, is to be applied to the court, or the period set by the court as available to a defendant to set aside an order for enforcement under 6218(9). That's the relevant point. So that's from your perspective.
Yes.
He's saying that because there are so many different orders here, I'm not quite sure which one he's concerned with, to be honest. Because there's the order which under 6218, I think it's the 6218 order he's talking about, isn't it?
He is, my lord,
He's not
yes.
talking about what I've described as the realisation of the debt by taking proceedings for attachment or charging order or whatever. So from your perspective, he's talking about the order under 6218. He's saying it does fall within 12.1 and 12.2 has to be adapted in order to deal with that order. So,
Indeed.
so you rely upon him for...
Yes.
Is it, and this is what, part of the ratio, or is this obiter?
It is part of the ratio, but as Mr. Toledano says, the points that we're arguing about today were not raised in argument. Mr. Walker did not run the arguments that my learned friend is running, essentially. And I would say, obviously, for obvious reasons. But the other point, my lord, also, if you go into the previous subparagraph, number 4,
Well, he actually, yeah, well, you say it's part of the ratio, but in fact he had already decided, hadn't he, that the Morrison order had to be set aside anyway.
I think you're
So the first issue in the case, which is issue 1, detail doesn't matter.
Your lordship is right, yes.
But so in fact this is all obiter.
It is.
You accept that?
I accept that.
It is it's obiter because he'd already decided to set aside the Morrison with the...
But
yeah.
But it's a decision of that particular judge is deserving of a great deal of respect.
And it was fully argued. So
Well, the other point at sub 4 is relevant as well, because this is relevant to one of the safeguards and one of the policy points behind section 12. As it seems to me, he says, section 12 means what it says. It deals with procedure. It's not to be confined to the court's adjudicative jurisdiction. The 2-month period is an acknowledgement of the reality that states do take time to react to legal proceedings. It's understandable that states should have such a period of time to respond to enforcement proceedings under section 100 following of the 1996 Act. Not untypically, an award will be made in one country, but enforcement may be sought elsewhere, perhaps in a number of jurisdictions. I therefore decline to read words into section 12 so as to preclude its application to the enforcement awards under CPR 6218. But so that's one of the, I won't say mainstay, but one of the factors that is behind Mr. Lord Justice Mails's decision when he goes through in detail the provisions of section 12 and why he reaches the conclusion that it must be the case that some document, or it must have been contemplated by Parliament, that some document would be served within the meaning of section 12 on a state. And these are part of the reason. It's one of the safeguards that is provided.
So, right, okay. but he's dealing here with the. This is the third-party debt order he's dealing with here. Is that right?
That's the Smith order.
Yes.
Yeah. So this is the Smith order, but that is that not that's at a subsequent stage? But I don't understand. Again, you have to help me on this. That seems to me to be like a charging order, effectively, isn't it?
Garnishee.
Or a garnishee.
Yeah.
Whereas what we're talking about, and what the Morrison order was talking about, is an order permitting enforcement of the judgment. isn't it?
I think the way it works is that the first issue was whether the Morrison order was, as it were, bad and had to be struck down, which he decided it did. And the second issue was, even if it wasn't, was the third-party debt order premature because the Morrison order should have provided for the 2 months period in section 12, in addition to the 21 days. And the reason why Mr. Justice Gross decided that it should so have done is that it was to be regarded as the document which was required to be served for the purposes of sections 12.
Yes, but I think
One.
I do understand that. I think I'm making another, almost certainly a terrible point, but I'm going to make it anyway, which is when you talk about enforcement of an award, the first stage is you need to have it registered or recognised as a judgment of the English court, as a debt.
What you do first stage is you get permission to enforce.
Yeah, yes. But you get permission to enforce, and in this case, for example, what happens is the amount of the award is recorded as a judgment debt in the order. That's stage one.
Yes.
That's the equivalent of obtaining an ordinary order in proceedings in this country against a defendant for a sum of money.
Yes.
There is then a subsequent process, which in the ordinary circumstances I personally wouldn't have thought of as starting fresh proceedings, which is simply the realisation of that order by one of a number of mechanisms, which could be garnishee, it could be charging order, all of those sorts of things. Those are two different things. I had always thought, until you took me to this case, possibly because I'm still lagging behind, that 6218 was dealing with the first of those steps, not the second of those steps. And so the additional confusion I'm now under, apart from the paragraph 1, subparagraph 1 of paragraph 25 of this judgment, is that this judge is treating that second stage, the garnishee type situation, as also within 6218. And is that right?
Well, let me just say, I think my Lord Flaux, Justice Flaux explained it correctly, that the position is that he knocks out the Morrison order because he knocks out the Smith order because the original Morrison order didn't comply with section 12 of the State Immunity Act. Therefore, the subsequent garnishee order or third-party debt order had to go.
So when he's talking, I understand that, but in 25.1, is he talking in 25.1 about the Smith order and the absurdity in relation to that, or which is stage 1, or is he talking about? So is he talking about the Morrison order?
He's talking about the Morrison.
He's
He's
talking
talking about the Morrison order, not the Smith order. Although this is headed the Smith order.
It is,
All right.
it is confusing, yes.
Right, I understand that. So this is all actually, although it's under the heading, the Smith order, it's all about the Morrison order.
Yeah.
I'm sorry.
No,
At least I tried to understand. Right, now I understand.
And then subsection 6 says, in the result, the Smith order cannot stand because, for these reasons as well, the Morrison order can't stand.
yes.
Is that the point?
That's the point, my Lord. Yes. That's the point.
Maybe that's why it took 7 years to be reported.
Right, so you say this is
gold mine of information.
So you say this is although obiter strictly, I'm not sure we have to think about whether it's obiter or not, but you say strictly, I'm not sure this is obiter actually. No, I'm not because to be honest, if you're telling me that the Smith order, if you're now saying that the Morrison, as we seem to be all agreed, that the reason that the Smith order couldn't stand was because the Morrison order had to go, and the reason the Morrison order had to go was because of 25(1) to 5, then it is part of the ratio.
No, I don't think that is what he's saying, because I think what he's saying is that the Morrison order was defective. If the Morrison order was
For other reasons.
was a good order, it should have included a longer period. It should have included the 2 months.
The answer is he could have dealt with it the other way around if he wished to, but his judgment is he could have started with issue 2 and then
No,
said,
the Morrison order had to go because the Morrison order impleaded 3 separate people, whereas the arbitrator's award only impleaded 2.
Yes,
Therefore,
right.
the
That's
Morrison
the
order
point.
had to go,
That's the point.
and therefore everything else is overturned. If, on the other hand, he was wrong about that, which I may say so he clearly wasn't, then I suppose it would be relevant to see whether the Morrison order was invalid for other reasons.
But he wasn't. And if you look at 26 on page 571, at the letter B, where he says, while as a matter of jurisdiction, it cannot matter that the Morrison order said nothing about a 2-month period. It would have been more desirable if it had done. So this is all on the hypothesis that the Morrison order is otherwise a valid order.
yes,
But the reason the Smith order can't stand is because it was premature.
yes,
Because the Morrison order should have been served in accordance with section 12, subsection
it did.
1. Okay.
Which is the reason why I rely upon it, inevitably.
Fine.
In fact, the Morrison order was served in accordance with section 12.1.
Well, it,
So one actually wonders what this is all.
Yes, quite.
well,
It's getting very little help out of this authority, although
no, it didn't comply. It didn't comply. No, it didn't comply with section 12(2) at all. They did serve it, but it only provided for 21 days within which to appear
Should have provided for 2 months.
from date of receipt.
Yeah.
You get a clue actually if you look at paragraph 24 from what it was that Mr. Walker was arguing. It's all to do with section 12(2) and the period of 2 months
Yes.
for acknowledging service or entering appearance or whatever. And his argument was this isn't within 12(2) because it's the this is not the adjudicative jurisdiction, it's the enforcement jurisdiction.
Yes.
That was rejected.
And that's
Correct.
rejected. Yeah.
So that was rejected, and therefore 12(1) applies. And then 12(1) applies. Now this order was in fact served. That's right, is it?
It is, my lord. Yes, that's it. Right.
So that's why. So that is the reason. That is the reason why 1 and 2, 25(1) and 2, and 3 are obiter. Because it was in fact served.
Well, no.
Therefore 12 was engaged. Therefore on his analysis 12 was engaged.
It was served, but it wasn't. It was served, but it didn't comply with section 12(2), the order. Is the point? Because it only provided for 21 days, not the 2 months. And his lordship is saying 12(1) and 12(2) go together. You can't have one without the other.
So, well, I mean, what Mr. Walker was actually trying to argue was pretty well unarguable, wasn't it, in one sense? Because what he was trying to say is even though we served in accordance with section 12, subsection 1, you can sort of ignore that, and because section 12 doesn't really apply at all.
Yes.
You can see that wasn't necessarily the most
Not
attractive of
particularly
arguments.
attractive, but
Anyway, we'll have to
But-
work out what we can get out of this judgment. We better move on.
well, Lord, the other point is, of course, that this is referred to and relied upon Mr. Justice Hamblin in the LVY Government of X case, which is at tab 18 of your bundle, the same bundle, which is a slightly different scenario because this was a peremptory order and the enforcement of the peremptory order. But it's worthwhile, your lordships, being aware that this case, if I could ask you just very quickly to look at it, it's, well, we're there at tab 18, and as I say, this was a peremptory order made in an arbitration proceeding which was then sought to be enforced under section 42 of the Arbitration Act. and Mr. Justice Hamblin effectively relied upon Mr. Justice Gross's decision to say, well, in relation to Section 42 proceedings, the State Immunity Act in Section 12 obviously applies to that as well. And you can see that, my lords, it starts at paragraph 23 on page 3953.
Well, the reason is because the argument was being run was effectively, as he says in paragraph 31, it was a very similar argument to the point about adjudicative versus enforcement. Counsel was trying to argue that this isn't instituting proceedings, it's just effectively enforcing the peremptory order of the arbitrators.
Indeed, yes. And his lordship said, no, that's not right.
Yeah.
It plainly does come with it, like with Order 16 Rule, CPR 62 Rule 18. This also falls within the ambit of Section 12, and you can see he deals with the Norsk Hydro decision from paragraph 38 onwards, my lord.
Yeah.
So which paragraphs you relying on?
Paragraph 38, my lord, at page 3956. Where you'll see it says, further, if as the Norsk Hydro case decides, Section 12 applies to enforcement proceedings, then the present case must be said to be a fortiori. And then 39, yet further, the consequence of the claimant's arguments would be to impute to Parliament an unlikely intention to confer the procedural rights in Section 12 in respect of various things there, including applications under the 1996 Act and Part 62 to enforce arbitrations awards, but not an application under Section 42. And then 40 is relevant. As to 3, the claimant's application to the court under Section 42 is in substance instituting proceedings against the YRG. It involves bringing the YRG before the court for the first time in order to participate in court proceedings brought for the purpose of obtaining a court order. And my lords, I pray that in our case as well, because in substance, instituting proceedings here is the requirement that the order be served under 62.18, and it involves bringing Libya, State of Libya, before the court for the first time in order to participate in these court proceedings. And that's
You say
why
any document which calls the defendant to court for the first time must be served, and must be served in accordance with Section 12.
my lord, yes. And that gives a purposive instruction to Section 12, which is what Lord Justice Mayles was doing. And it's wrong to say, there are two things to say here. First, it's wrong to look at the wording in Section 12.1, instituting proceedings, which is the key word for my learned friend here, and try and imbue with that, well, you can only look at the CPR to understand what instituting proceedings means. His case is you look solely to the CPR to understand what that means. You don't look at the State Immunity Act in its context. You don't look at Section 12 and its sections in their context and the policy reasons behind it, which is what Lord Justice Mayles did. And the second point to note is it's wrong to say that Lord Justice Mayles' arguments were circular because there was no analysis. When you were taken to paragraph 38 of his judgment, my learned friend says, oh, well, if you read that, it's a circular argument because he contemplates that there will in every case be a document that is served, is my lord's point. Well, the reason he has that statement in there is because he's already gone through the reasoning and analysis as to why he says that is the case. And that's paragraphs 29 to 36, I think, of his judgment, which, given the time, I'm not going to go through each one of those points, but they're all very valid points. And one of the, I say I'm not going to go through all those points. There is one point I will advert to there, my lords, and that is,
I don't see why, where L and Y, this case of Mr. Justice Hamlin, gets you any further than basically saying that Section 12 isn't confined to an adjudicative process. And it applies, as in the case of Justice Gross's judgment, it applies to enforcement of a money order, a money award. Well, how does it get you any further than that? And I don't believe it's in I didn't understand it being in dispute in this case that enforcing an award does fall within Section 12. Now, Mr. Justice Gross went further, Mr. Justice Hamlin, because he tried to analyse if we adapt his words to serving a claim form, either to issuing a claim form and either ex parte or served, and he was saying, obiter, I think you're accepting, that there shouldn't be a different result, whether it's actually required to be served or the process is starting ex parte. You've got that point, and then you've also got the point that he does appear to accept that an order made pursuant to the CPR 6218 also falls within 12. You've got those from Justice Gross's judgment,
Yes.
and I followed that eventually.
Yes.
But I don't see what more you get out of Justice Hamlin's order other than the general point that it's not confined. Section 12 is not confined to an adjudicative process.
well, I don't get more from what I get from Mr. Justice Gross's decision, I don't think, my lord. I mean, if you're saying, if it's accepted from that decision, it's implicit in what he says, as Lord Justice Mayles found, that if an order is required to be served under 6218, then that falls within Section 12 of the State Immunity Act. That's the main point. That's implicit from Mr. Justice Gross's decision.
Well, the point about Mr. Justice Hamlin's case is that in order to get an order under Section 42, you had to issue an arbitration claim form. So it was a case where you had to have an arbitration claim
Yes.
form. So by definition, which is why he says it's A40 or I
Yes.
in paragraph 38. And then earlier in his judgment, I think in 23 or 24, he talks about proceedings being started by the arbitration claim form. So in a sense, it's a you know.
It doesn't take me any further, Mike. Your Lordship is quite right in that
Doesn't
regard.
really.
But I do prenade the point at paragraph 40, which is a general point. It's a general point of principle.
Claimant's applications are called under Section 42. That's an application to enforce
A peremptory order.
a peremptory order, which is a money order. It's a money award.
It can be an order requiring a party to do something in the
I
context.
think
of
in
the
that case it
arbitration.
was an order to pay money.
It was,
actually.
But it could be anything.
Yeah.
Sort of interim payment order, was it?
It was, I think.
It's all right. So it's an application. So it's an award. It's an arbitral award for payment of sum of money. In this case, it's in substance instituting proceedings. But well, fine. I don't think that's in dispute.
He again. It's just the problem of dipping into these things. When he says as to 3, I take it that's actually a reference back to paragraph 29, subparagraph 3, where he sets out the claimant's submissions. So this is addressing the claimant's argument that this wasn't instituting proceedings, it was simply an application in support of existing arbitration proceedings.
Yes. Yes.
So what I'm trying to say to you is, Mr. Justice Hamlin, in his judgment, as far as I can see, doesn't deal with the matters on which you rely, particularly in paragraphs 25, 1, 2, 3 and 4, Mr. Justice Gross's judgment. He doesn't get that far, doesn't need to
He-
deal
all
with
it- all-
any of these issues.
He doesn't matter. All he does is to cite it with approval,
So
effectively.
it's just he's citing it with approval.
Yeah, paragraph 38.
All right.
But I do also pray in aid, as I say, at paragraph 40, there's the point. It's just the general observation he makes that instituting of proceedings involves bringing the party before the court for the first time in
Right, so
order to
you rely on those
participate.
words.
Yes.
It involves bringing the YRG. So I mean, although it's on in relation to a different point, you want to apply those words to our case.
Indeed.
I see. It's
Sorry, I was being a bit opaque or trying to move too quickly. Is more the
court proceedings. Yeah. Right. Okay.
and that is relevant in the context of the order that is made by Mr. Justice Teare under the CPR. Now, my lords, I'm not planning to run through now the steps that Lord Justice Mayles goes through to reach his
I
conclusions.
want to take you up on that point because that's quite an important point. Are you correct in what you say about the relevance of that sentence? Because it's talking about bringing a party before the court for the first time in order to participate in court proceedings brought for the purpose of obtaining a court order. I mean, in our case, the court order's been made. So that's why I'm saying he's really dealing with an earlier stage, which is are the proceedings to enforce a peremptory award within section 12? That's at an earlier stage. We're now at a later stage where the order's been obtained. So can you simply rely on those words as they stand?
Well, not necessarily those words, but the purpose behind them and the context.
Well,
my context is different.
But that's why I said to you, when he says as to 3, that's a reference back to paragraph 29,
It is,
section 3.
yes.
Because what he's addressing is the argument that this wasn't institution of proceedings because it was simply an application in relation to existing arbitration proceedings. And what he's saying is, no, the fact that you've got an arbitration on foot is neither here nor there. So far as the court proceeding is concerned, the claim form initiates the court proceedings. That's all he's saying, isn't it?
Well, it is what he's saying is defining what is meant by instituting proceedings, and that's a key point for us under section 12.1. And what I am saying is, in the context of the State Immunity Act, section 12, instituting proceedings means the service of the document on the state that invites the state to actually take part in the proceedings. That is the instituting of proceedings, because if you just have a claim form that's not ever to be served, the state doesn't know about it. It may be that under the CPR the proceedings are started, which I think is the word used into 62 Rule 3, but the proceedings aren't instituted against the state until the state is served with something. That's the whole point of what Lord Justice Mayles is saying, that your default position is that you expect, if you're going to be party to proceedings, to be served with something. And in the context of section 12 of the State Immunity Act, it is imperative that at least something is going to be served, and that's what section 12.1 is dealing with. And one of the points I was going to make, my lords, is that section 12 is not there just for the benefit of the state. It does strike a balance of interests for both parties. Another point that Lord Justice Mayles makes, that you have the provision under section 1 requiring service through the FCO, which is a benefit or is a safeguard to the state and protects the sensitivities of state versus state and bringing a state to these foreign state to these courts. But the important point also in section 12.1 is the deeming provision, where it says that service, if you've got it in tab 1 of the First Authorities bundle,
Yes.
Shall be deemed to be effective.
Shall be deemed to have been effected when the writ or document is received at the ministry. Now that is a factual question, and what it does is to give the claimant the benefit of knowing, well, all I have to do is to give my document to the FCO effects service, and when it's received, that's it. That is when time starts to run. He's not bothered by any local laws or anything of that ilk, because that's what section 12.1 provides for.
So someone from the embassy just puts it through the letterbox of the Ministry of Foreign Affairs, in this case in Libya, that is the receipt, and the fact that the state might say there's a law against receipt, or we don't accept it, or there's nobody there to receive it, because the office is closed because of insurrection, is nothing to the point.
Well, my lord, yes. And my learned friend raises a point, the Mr. Justice Lewis decision in the Brazil case, where his lordship suggests that section 12.1 cannot be contemplated applying in a situation where it might be held to be illegal in the foreign state for service to be effected in that manner, or something of that sort. Well, with all due respect, that's not what section 12.1 says. 12.1
Normally one uses the word delivered, doesn't one,
yes,
to express the concept
Yes.
of delivery.
Yeah.
Receipt does imply that someone receives it.
and but the sorry, I get caught up. The point that was also made in the Syria case, you recall the Syria case is in the bundle. There was a series of decisions whereby there was difficulty serving Syria in respect of proceedings brought by the EU effectively against Syria, and it was resolved by service being effected by email by the FCO, and that was held to be valid service under section 12.1. And so we can see the development of, no doubt, jurisprudence in relation to, well, what does received at the ministry mean? But what the point I'm making here is that once that is done, the claimant knows where he stands, and it's deemed to have been affected at that time.
For my part, I'm a bit reluctant to get involved in a question as to what receipt precisely means. We've got quite enough to decide in this case. Normally, your concept would be expressed by the word delivered.
Well, my lord, it may be that we don't need to get into the debate about
I don't think it undermines your point basically is whatever its meaning,
it's the deeming.
it makes a provision, a deeming provision.
Indeed.
Yeah, I mean,
Whatever, I mean, it may be it's not clear. But can I'm sure this is clear. I just want to record it formally. But your position would be that if the claim form is required to be served, that is the commencement of the proceedings. That's the institution of the proceedings,
It would be the,
according to your definition.
yes.
That would mean you would accept, therefore, I think, that the order in such a case, the court could exercise its powers to say that the order doesn't have to be served in the ordinary way.
That's an interesting point, my lord.
Well, it wouldn't. I mean, according to your definition, it's not that order which brings the party before the court for the first time. That would have been done already.
Well, if the claim form is served in accordance
Yes, it's
with
required to be served.
yes,
And it has to be served. I don't think that's in dispute. That if it's required to be served within section 12, must be served in accordance with section 12. I don't think that's it. Don't think that's in dispute. It would follow, it seems to me, unless you tell me otherwise for some reason, that in such a situation the court does have power to exercise its other procedural powers to provide for either no service or some different form of service.
well, Well, in respect of the order,
I'm not trying to trick you up. I'm just trying to make sure I understand.
well, I'm trying to understand what your lordship is obviously saying, but I have a slight problem in the sense because 12.1 and 12.2 sort of go together, and 12.2, while we're on it, if I could just ask you, it says, any time for entering an appearance, whether prescribed by the rules of court or otherwise, which are important, shall begin to run 2 months after the date, etc. Now, if you've got a claim form, it has to be 2 months. If you've got an order, and it's the order that requires the appearance of the state.
Is that right? I mean, doesn't the claim form have to be? I thought we were saying that the agreement of an appearance is an acknowledgement of service.
Well, no, I think the claim form in the context of a 6218 doesn't require any appearance. Indeed, we've got the...
Doesn't it require an acknowledgement of service?
No, I don't believe so.
That's why you proceed directly.
That's why it's-
Yeah.
yeah.
For giving permission to enforce this judgment.
Yeah. You've got the arbitration claim form in the bundle.
It is, my lord.
Where is it in the
It's at the back of the core bundle, tab 10.
okay. Cool.
The question is, does this have to be accompanied by anything else?
See, that claim form doesn't actually...
You wouldn't normally find it in the claim form, would you normally find a separate kind of service? I don't know.
But it's the order that is...
Anyway, I just want to get your submission on this.
Well, the fact of the matter is that 6218, the way in which it operates, is unless either on the paper application or as in this case at the hearing, because Mr. Justice Teare decided quite sensibly to have a hearing, no doubt because it was enforcement against the state. If the court decides pursuant to 6218(2)
Yes.
that parties must be served, then the claimant would have to send the full pack to the relevant defendant, so that would include the acknowledgement of service forms. So the fact that this claim form doesn't say anything about service is neither here nor there.
No. Well, that's because, it was going...
It's in a
ex
standard
parte,
form, it's a claim form in
it
arbitration.
probably would be, my lord, it probably would be the position that you would have the claim form, if it had to be served, you wouldn't have the order made at that stage.
No, it wouldn't be that stage. That's the point I'm trying to make.
Yes, sorry.
The point I'm trying to make is if you accept that we're in a case where in a case where the court does, pursuant to 6218(2), order that the claim form must be served, my assumption would be it's accompanied, as my lord says, by the pack, which includes an acknowledgement of claim form. If that is correct, then that would be, those are the documents relevant for 12.1 and 12.2.
Yes.
So the only point I'm trying to make is, it would seem to follow, therefore, that when, if then an order is made, let's say the claim form is served and nobody turns up,
Yes.
in a Libya type case, then the court might say, well, there's no point in serving the order through the Foreign Office. Let's just get on with it and we'll do what he did here, apply for notification or whatever. And that would be consistent with your analysis.
Yes.
So that's all I was trying to get at. So in those circumstances, the stricture about having to serve the order through the means in 12.5 wouldn't apply.
And indeed, that's a similar point to that arose in the Syria case in front of Mr. Justice Bryant, where there had been service had been affected through the FCO eventually on Syria, and then there was an application in the proceedings for further relief or for the summary judgment.
Summary judgment where they
The
hadn't
summary
acknowledged
judgment.
service.
Exactly.
So they'd served them, no acknowledgement of service,
Yeah. And,
application for summary judgment.
and the point was whether that fell within section 12 or not, or under 644, which I'll come to in a moment, or not. And his lordship said, no, it doesn't, because the proceedings are already on foot,
That's well.
which is
That's all the only point. So I wanted to say that the structure of your analysis is either by service of the claim form, or if it isn't by the claim form, then by the order. There has to be you have to serve it in accordance with 12.5. It's one or the other.
Yes.
It never has to be both.
no. All right. Now, while we're on 12.2, and we've got I think we did have the order open of Mr. Justice Teare previously, which is in the supplemental bundle at tab 1, and I don't know if my Lord Justice Longmore has got a document now in that relevant.
Yes, thank you.
There's another point I'd like to make on this, because
Supplementary bundle tab 1.
supplementary bundle tab 1, but if you could also at the same time keep open please section 12 of the State Immunity Act. And you'll see that the order of Mr. Justice Teare was that the defendant, paragraph 6 on page 2, so the defendant may, within 2 months of the date of this order, apply to set aside this order, and the award shall not be enforced until after the expiration of that period. Now, if one looks back at subsection 2, under section 12, it says any time for entering an appearance, whether prescribed by the rules of court or otherwise, shall begin to run 2 months after the date on which the writ or document is received as aforesaid. Now the use of the words or otherwise are quite important, because it takes one outside the scope of now the CPR. And or it could be still within the CPR. But the fact of the matter is that this order stipulates a time for entering an appearance on the part of the state of Libya. And
It doesn't. All it says is the award shall not be enforced until after the expiration of 2 months.
well, the defendant may apply to set aside.
Yes,
So-
if the
so-
defendant applies to set aside within 2 months, then until after the application has been disposed of.
The way in which subsection 2, 3, 4 and 5 operate is that you have to enter an appearance within 2 months of receipt, and if you don't, you're in default of appearance,
Yeah,
and you get judgment in default. The way in which this scheme under 6218 operates, as Mr. Toledano submitted to us this morning, is there is no default. I mean, what paragraph 6 does is to give the defendant a choice. For example, I mean, it may not be this case, otherwise I assume we wouldn't be standing here, Mr. Davis. The state of Libya might not have any assets in the United Kingdom, and they might take the view, well, it's just not worth the candle. They're employing leading counsel to argue this point because we haven't got any assets. But if that were the case, if that is what had happened, all that would happen is, as my Lord says, is that the 2 month period expires, after which they can enforce if they can find some assets.
they can enforce, but this is saying is giving a time within which we are to enter an appearance under this
Well,
order.
so you say. Yeah.
Well, that's what the order says, my lord.
Well, it doesn't say anything about entering an appearance. It talks about applying to set aside the order.
It gives us time for entering an appearance to set it aside.
Well, time for making an application to set aside. Yeah.
But the point is that 1 and 2 very much go together here, we say. And the deeming provision as well is part and parcel of that.
So as I understand it, the reason you're making this point is you're saying, look, the reality of it, whatever the niceties of the wording of 812.2, you're saying the reality of it is that you can see that this order, Mr. Justice Teare, actually is an order for the purpose, it is actually falling within 12.1 and 2, because in reality, paragraph 6 is a reflection of what is required under 12.2.
Yes. It purported to be, it was sort of a halfway house that was adopted in this case, by Mr. Justice Teare. He used the 2 months, but he does it from date of the order. He doesn't relate it to date of receipt, which is part of my difficulty in understanding, well, if we're not in the realms of section 12, what procedure are we following? What rules apply to tell us what time limits there should be inserted in an order such as this?
Well, but that's a slightly different point. At the moment, we're considering the point of principle.
Yes.
Well, the answer to that question is we're in the second part of 62.18 sub 9. Within 14 days after service of the order, or if the order is to be served out of the jurisdiction, within such other period as the court may set. And Mr. Justice Teare exercised that discretion to set a period of 2 months.
He did, my lord, but it, by doing so, replaces what is a very carefully orchestrated scheme under section 12 with all of its safeguards therein, and it leaves it at large, knowing what is to be set by way of a...
I think we're now getting terribly confused. I think you should stick to your point of principle at the moment. At the moment, we're dealing with the point of principle. It is the order, the institution of proceedings for the purpose of 12.1. That's what we're dealing with at the moment.
And if I could, on that, just pick up, then go to 62.18. Now, your lordship has already been taken to this provision. This could be important at this stage. We're going to go back in a moment to CPR 644. But the scheme at which we have, as we've seen, under 2, that the court may specify the parties to the arbitration to whom the arbitration claim form must be served. And if we go on to 7, as Mr. Toledano has taken you to this already, but and this is an order giving permission, that is permission to enforce, must, so it's mandatory in terms, be served on the defendant by, and then we've got sending a copy or to him personally or to his usual residence of business. And then 8, an order giving permission may be served out of the jurisdiction. B, in accordance with the rules 640 to 646, as if the order were an arbitration claim form. Now, I pause it. This is giving you the answer, my lords, in clear terms. The order is effectively the arbitration claim form. It's to be treated as if it were the arbitration claim form. It's taking its place. Because the claim form at this stage is not required to be served.
Well, that's why I asked you my question about what the position would be if the claim form was served. I mean, the wording in 8 doesn't apply only if the claim form hasn't been required to be served. It applies in all cases.
Well, if the claim form is required to be served, the likelihood is that a different procedure would then be followed.
Well, it may be likely, but the rules don't expressly provide for it.
They don't, my lord.
I mean, it may be that you're right in the sense that the court might order notification, as it did in this case, but I mean,
I mean, you've got a wider point. I mean, I see what you're saying, but I think I see what you're saying, because you're saying the reference to as if the order were an arbitration claim form in a case where the arbitration claim form hasn't already been required to be served indicates that it is of the same nature.
Indeed.
And I think that's what you're saying.
Indeed.
All right.
Yes. So as to come within the ambit and meaning of section 12.1
Yes.
of the State Immunity Act. And
I don't think this was the point. I don't remember the judge making this point.
it certainly was an argument that featured heavily in my argument below, but he did not deal with it.
In his judgment.
He obviously didn't see the need to deal with it in such detail.
But I mean, and the other way of looking at this, which I think is what Mr. Toledano said, is the reason why it's as if it were a claim form, is to make it clear, or to avoid any possible argument that having said that you had to do it in accordance with rules 640 to 646, that some bright spark would say, well, hang on a moment, 640 to 646 only deal with service of the claim form, therefore it can't apply.
Well,
It's saying for the purposes
it's
of
making it clear.
service, for the purpose of the service, those rules apply as if this were a claim form. It's not saying it is a claim form.
It is imbuing it with the character of the claim form and we're here interpreting what does section 12.1 of the State Immunity Act mean. Is the order in this case of a type that falls within the definition of a document being required to be served which institutes the proceedings? And here you have the CPR explaining to us, well, you have the order which is to be treated as if it were an arbitration claim form. Mm-hmm. It's pretty stark and clear with respect, and even more so when one goes to 644. If I ask your lordships please to, in this little clip, it's page 339. 339.
This is a slightly different point.
It is.
This isn't really. Now we're moving. So there are 2 points. There are 2 points you're making here now. So the first point you're making is from the point of view of section 12, that where a claim form hasn't been required to be served, 62.18.8, you say, gives you your purposive interpretation.
Yes.
The rules themselves make the analogy with the service of claim. Then you're going to make another point. I think you're making now a separate point.
I'm now going to make another point.
Separate point, which is to say, when it says in 62.8b, as if the order an arbitration claim form, that brings with it, I think you're saying, 6.44.3.
Yes.
Just is at that point
it brings with it. It does bring with it 6.44.3, which is important because it replicates effectively the State Immunity Act position. But even more importantly is 644.1, well, not more importantly, but just as important, where you'll see the wording used is that this rule applies where a party wishes to serve the claim.
Where are you reading from now?
6.441.
The text, the commentary.
Yeah. No, at page 339. it's at the very bottom of the page, my lord, under the heading Service of Claim Form or other document on estate. It says this rule applies where a party wishes to serve the claim form or other document on estate.
Yes.
Now,
And the significance of that is
well, this is Mr. Justice Bryan has held that the wording here replicates or is intended to replicate the wording in section 12.1, i.e. the instituting of proceeding. Any writ or other document.
Well, is this your point about the absence of a power to dispense with service?
No, my lord. This is a point that is I'm making, that the arbitration claim form, the order, Mr. Justice Teare's order under 6218 is to be served as under 644 as if it is an arbitration claim form. You then go to 644 and you'll see there it is said that this rule applies where a party wishes to serve the claim form or other document on estate, and that has been held by Mr. Justice Bryan to mean the same as section 12.1 of the Supreme Court of the State Immunity Act. And if that is right, and that my order is coming under 644, it must also come under section 12.1 of the State Immunity Act.
The difficulty with that argument is that other provisions in between 640 and 646 have similar words. I mean, 641, for example, says this rule applies where a party wishes to serve the claim form or other document in accordance with the service regulation. And then 643, I think, says this rule applies where a party wishes to serve a claim form or other document under Rule 642 or 642. That's through consular authorities. So it's...
Well, I want to make sure your lordships understand what I'm saying here, because 644 is the only relevant provision within 640 to 646. It's the only relevant provision so far as we are concerned with the service on estate, and that relates to, in this instance, under 644.1, is replicating what's required under Section 12 of the State Immunity Act. That's its purpose. And
Well, are you saying that Mr. Justice Bryan held that a claim form has to be served through the FCO? An arbitration claim form has to be served through the FCO in all cases.
no, I'm not saying he
What's
said
the point of referring to Mr. Justice Bryan's case?
Well, let's look at
Why
what
don't you show it?
Yeah, I will do. It's if I could ask you to go to tab 21, it's Authorities Bundle 2.
Yeah.
And if I could ask you to turn to paragraph 30.
Which tab is it?
Tab 21, my lord.
Again, this is an ex parte application, or at least not an inter partes application.
Indeed, my lord. This was the one whereby the EU was seeking summary judgment against Syria.
Yes.
So service, and if your lordships pick it up at 32, paragraph 32, you've got the issue of service, and at paragraph 35 we see, set against the background of the order of Mr. Justice Teare of February 18, there has already been found to be valid service of these proceedings for the purpose of the
What were the proceedings for? Enforcing an award.
Enforcement.
Yeah, enforcement, my lord.
Of an award.
I'm not sure. I don't think it was an award, my lord. I think it's just a money.
Yeah, I think it was. I think they're seeking to enforce
It's a loan agreement.
the repayment obligations under loan agreements, isn't it?
It's just an ordinary action
It's just an ordinary action, my lord. Yeah.
for repayment.
Yes.
Yes. Well, an interview, that is a document, that those issues should be issued by writ, claim.
Or claim for. My lord,
Yes.
yes.
And that was served through the FCA. So why does it have any relevance whatever?
Well, I'm going to show your lordship now. If one goes to 39, paragraph 39. Well, 38 says in this regard, 38. So far as service of the claim form is concerned, as is already foreshadowed and dealt with by Mr. Justice Teare, Section 12(1) of the Immunity Act provides then as follows. Then 39, now that is concerned with service of a writ or now modern termination claim form or other document required to be served, it will be seen in the context of the State Immunity Act, the words or other document are linked to documents which are required to be served for instituting proceedings. In other words, for another document to be relevant, it is one that is required to be served for instituting proceedings. However, in the CPR that exists, there is provision relating to serving a claim form or other document, and then he recites 644. And then it's submitted to me today by Mr. Beltrami QC on behalf of the claimants that this provision of the CPR is directed at service of the claim form or other document required to be served for instituting proceedings. In other words, the words or other document are referring to the documents of the nature which are identified in section 12(1). It is those documents, i.e. claim form or other document required to be served for instituting proceedings, which must follow the service procedure in 644. It seems to me that that is proper and right construction. Therefore 644 is not concerned with service of documentation once proceedings have been served upon a state, which is my lord's point. But the point I get from this is that his lordship is equating 644(1) with section 12(1) of the State Immunity Act, and if we are told by 6218 8b that the enforcement order is to be treated as an arbitration claim form and falling within 644, it must follow that it also falls or is intended to fall within section 12(1). That's the point. Because if the enforcement order of Mr. Justice Teare falls within 6...
I mean, what Mr. Justice Bryan was dealing with was, if you like, the precise opposite. He was dealing with an argument that said, even though they've already been served, the application for summary judgment has to be served pursuant to section 12(1) of the State Immunity Act, because that's the effect of 644. And he says, no, it isn't, because this is all about documents used, documents required for instituting proceedings.
My Lord,
Begs the question as to what document is required for instituting proceedings.
My Lord, I understand that, but what the point that His Lordship is making is that the 644 is replicating section 12(1). And if a document falls within the scope of 644, why does it not also fall within the scope of section 12(1)? That's the short point.
It's slightly in danger of getting swallowed up by the detail. My understanding is, looking at things globally from your perspective, what you say is, look, it's clear that, and accepted that if their claim form is required to be served, it falls within 12(1), and that is a balancing mechanism that protects both sides. In a case where there isn't, that isn't ordered to be done, what the rules tell us is that the order itself is to be served as if it were a claim form, and 6.44 says that's to be done by way of service in similar terms to 12.5, And therefore, if we're looking at this and the policy behind it, we're to applying 12.1 to the facts of this case and the rules, we are to regard the order in this case as falling within 12.1. And you see that's supported by the rules themselves. That's what we have to case. Yes. We'll say therefore both policy and the rules themselves, in the facts of this case, indicate that 12.1 is to be so interpreted, and that's the purpose of interpretation. I think that's what it comes to at the end of the day.
It's a fairly short point, my lord, and probably obfuscated the.
It's not obfuscated. I mean, I think, but I don't recall the judge addressing. Am I wrong about this?
He didn't
address this point at all, did he?
My lord, he didn't.
Did you advance it below?
I did do, yes. It's in our.
It is, of course, the essence of the judgment that the document giving permission to enforce does effectively require to be served, because it is effectively the institution of the proceedings as far as the state is concerned.
Indeed. Yes.
He doesn't deal with, I think, CPR.
He does refer to it, but he obviously didn't see it was necessary to deal with the present argument I'm putting to your lordships, no. But it was put before him.
Yes, thank you.
Lord,
Is there any more I mean, that's your case. Is there any more to be said on that point?
I'm sure there's a lot more detail in our skeleton, but that in essence is what I wanted to say on that element of the Mr. Justice Teare order. Then there's the power.
I think the nuance for me that I hadn't really picked up before, I'm not saying it's right or wrong, but you've brought out in your submissions, is you say that the rules themselves, particularly, you say 62.18.8 and 6.441 assist your interpretation.
Very much so.
I mean, I think that's the point you're bringing out.
Because it's not, as my learned friend's argument seems to be, that the CPR wagging the State Immunity Act. It's like the tail wagging the dog, is it, effectively. His submission is, well, let's just look at the CPR and see what is the appropriate interpretation to be given to section 12.1. With respect, he starts at the wrong end of the spectrum, and you should do what Mr. Lord Justice Mayles did, and look at the Act first, and then you look to the CPR and say, well, what document is it that satisfies the requirement of section 12?
And then you say you've got Mr. Justice Gross's judgment, which, whether it's able to or not, does at least address the issue.
And my lords, I would commend. I'm not going to spend time looking at it now, but the Van Zyl judgment of Mr. Justice Kanan Ramesh in Singapore is well worth a read, and I do commend that to you. It's dealt with in Lord Justice Mayles' judgment at paragraphs 74 to 77. And my learned friend has obviously tried to.
So the other way of looking at it, I'm so sorry to interrupt you, but I've got you on my mind. The other way of looking at it is to say, well, strictly speaking, the order doesn't fall within section 12.1, but the rules read together with the Act would indicate that in the case of an order, the court's discretion should not be exercised in favour of not effecting service in accordance with the terms of the rules. That's the other way of looking at it. In other words, the way that the court should normally exercise its discretion in a case like this, where the claim for has not been served, and where there's an application to vary by way of suspension or to disallow what would otherwise be the applicable provisions of 6.44. That would be the other way of looking at it. So that wouldn't be a question of statutory interpretation. That would be a way the court should exercise its discretion, either in all cases or say it's subject to the most exceptional circumstances. That would be the other way of doing it, wouldn't it?
Can I that is quite right, and I'm just going to make a couple of submissions on that element, if I can, but then I'm going to come back to the power to dispense with service, which I haven't dealt with yet. But I'm aware of the time, and I just want to make a couple of points, if I may, on what would be my respondent's notice in the light of those comments by your lordship, because obviously what we say in relation to that is set out in some detail in our skeleton. I'm not going to rehash the factual matters today in front of your lordship, but one of the key points to note in relation to that element, and the discretion point, we call it that, is that when Lord Justice Mayles comes to consider the alternative position, could he dispense with service if he had the power, or should he dispense with service, whatever the test might be, he effectively lost sight of where we were. He'd been through the analysis saying, well, we're within the realms of section 12.1, but when he then went to consider the alternative, he basically lost sight of my main submissions in front of him were, well, even if you've got the power to dispense, given the context of where we are and that the order, if it doesn't strictly fall within section 12.1, then you should at least be looking to, you need to be very careful before you do dispense with service, because you are in the realms of section 12.1, not least because of what Order 62, Rule 18 says and 644 says. You shouldn't adopt a fairly laissez-faire attitude towards that exercise. When you come to exercise your discretion, you need to be persuaded very clearly that it's appropriate to dispense with service. And in this case, where, and I put it as a point of principle, but where you do not have an attempt even to serve in the first place through the FCO, you have evidence that they had previously served enforcement proceedings in relation to US enforcement proceedings without any problem in Libya. They were able to deliver documents to the Ministry of Foreign Affairs in this case, but they didn't attempt to use the FCO. They did not submit evidence from the FCO in writing, such as you will see in the Havlish case, which was went to great lengths as to the problems with serving in Iran, which is what led Mr. Justice Teare to make the order in that case. We have nothing like that here. Indeed, the only documentary evidence we have from the FCO came from our side, and the indications were that, yeah, if you give us the documents, we will transmit them to Libya, where we do have consulate officials, and they will deliver them to the ministry. There was no promise on when it would take place, I acknowledge that, but that's the normal course. And you have here also that, you know, we are taking part in these proceedings. It's not, we're not in the realms of Syria or Iran cases where there is active evasion to accepting service. And a whole host of the circumstances in which Lord Justice Mayles relied upon related to matters which post-dated the original application in front of Mr. Justice Teare.
What does that mean?
Well, he took account of the changes on the ground in Tripoli, even as at the time he was writing his judgment. It's a natural reaction, obviously.
Well, what is the position about that? Obviously, one question is whether Mr. Justice Teare was right to make the order when he made it, but supposing he was, on the evidence before him, are you saying that no one can, at the inter-parties hearing, produce further evidence to show that now it's all right?
Well, I think the position is that as at it has to be assessed at the time you make the application. And so
And that's it. It's
and-
however much things may have changed,
You can-
as long as when it was in front of Mr. Justice Teare it was impossible, then that's written in stone forever.
You can look at subsequent matters that inform as to what the position was at the time before Mr. Justice Teare.
That must be the logic of your argument, and I suppose you would say, well, my Lord's point. You're absolutely right, because the issue for the court at the inter-parties hearing is whether the order was justified at the time when it was made.
Yeah.
And if merely because circumstances have changed since, it doesn't mean that the order wasn't a valid order when it was made.
Because it's very difficult, my lords, because, I mean, where would you cut it off? Would it be if things had changed now?
What you can do, according to Mr. Justice Hoffman, I think, in that case, is you can look at the later material to the extent that it throws light upon
What was
the evidence that was before the court on the ex
indeed,
parte.
because
application.
That's the only issue before us, is whether Mr. Justice Teare was right to make the order when he made it.
it is, my lord, yes.
I agree that's a point of principle, but do you have any authority for that? Is that what Mr. Justice Hoffman says?
Well, it's my learned friend was the one who cited the authority. It's the ISC case, Mr. Justice Hoffman, but it's not even in the context of this sort of application. It's in I think if I can find the ISC
You
case.
may be right, but I just find it a little surprising. It's very odd that if things are now perfectly feasible, it's now perfectly feasible to serve in Libya, that the court should stick its head in the sand and say, oh, we're only going to consider the matter. in
Mr.
the
Justice
ordinary
Hoffman was never known for giving surprising decisions, my lord. I'm sure. But if we, it's tab 12
I'm
of
not sure about that. You have to be very careful.
yeah.
It's a very broad statement.
It's tab 12. It was an application to set aside service out of the jurisdiction case, and it's page 434. And it's the bit that's highlighted in the tram line.
Well, I can see the force of that, of course, with all you're dealing with an application to serve out. But if you're dealing with an application to dispense service, is it really the same?
Well, my lord, it does lead to difficulties in that if, for example, there is material between Lord Justice Mails's decision and the present hearing, if there's material both parties want to deploy, are your lordships going to accept fresh evidence, for example? I'm not sure.
That would normally be a matter of the discretion of this court, and normally it would be exercised against the person who would want to put in fresh evidence, because once there's been an inter-parties hearing, of course, you look at the position as the judge made the order. But it's a little bit odd, isn't it, to have an ex-party hearing where you're stuck with the evidence that the claimant chooses to put before the judge.
Well, I'm not sure
You're
we're.
not stuck with it because you can show what evidence was at the time. I agree, but I would have thought that if the question was whether service should be dispensed with, one looks at it as it would be at an inter-parties hearing. But I may be wrong. But this is the only authority anyone's ever found on this.
I'm a little bit in the camp of my lord here. I'm trying to think of the proper analysis. So here, what is being said, as I understand it, by Mr. Justice Mails's position, was that Lord Justice Mails was saying that Mr. Justice Teare had exercised his discretion incorrectly. Is that right? I'm trying to work out where we are at the moment. So he is saying, yes, he is saying that in deciding to dispense, I'm just saying where we are, that in deciding, there are 2 points. One is he's saying that effectively Mr. Justice Teare was in error in the way he approached the whole question of service of the order.
But what he's saying is the point which you've yet to deal with, which is that there was no power to dispense with service.
Yes.
So he was wrong on that.
Yes.
But what he then goes on to say is, if there was a power to dispense with service, then Mr. Justice Teare exercised his discretion correctly,
Yes.
and I would reach the same conclusion on the basis of all the material that's now before me.
Yes.
That's effectively what he says.
That's what
Isn't it?
although he did.
And
He
you criticise him for relying upon anything other than what was before Mr. Justice Teare, other than, as it's put by Mr. Justice Hoffman, to the extent that that additional material can throw light upon what should have been relevant considerations at the time of the Teare order.
Well, to be fair to Lord Justice Males, he does in his judgment say that I have to look at this as at the time of Mr. Justice Teare's order.
Yeah.
But he then went on to augment his decision in what was, I think, paragraph 84, then with a host of other observations.
That's because, I think that because the proper analysis, I think, is if there was a power at the time of Mr. Justice Teare's order to dispense with service of the order, then the first question is, did Mr. Justice Teare act in an unprincipled way or reach a conclusion that no other judge could properly arrive at in exercising that discretion? In forming a view about that, that must be limited, it seems to me, to the material that was before Mr. Justice Teare at the time, because you're saying at the time he exercised that discretion, did he make an error of principle or reach a conclusion that no other judge could come to? That's the normal basis. So I think there's an amalgamation of two different things here. If you come to the conclusion that on the material before him he acted without an error of discretion, that's the end of the matter. But you could go on to say, even if he made an error of discretion, so that his discretion, as it were, so that it should be set aside, and I have to exercise it again today, in exercising it again today, I must take into account all matters that have occurred, including the position today. Those are the only two positions.
Well, not for Lord Justice Males on the inter partes, because it was afresh. He dealt with it afresh when we had the inter partes hearing. Because obviously the ex parte hearing is not binding as it.
Well,
as
all the
such.
more reason why, if he's looking at it afresh, he looks at the totality of the picture.
That must be right. I mean, if you're
In order
exercising
to exercise his own discretion.
right, if you're exercising your own discretion, you must do it on the basis of all the material before you. That must be right.
Well, I mean, I must say, when I saw this point in the skeleton arguments, I thought it was a thoroughly bad point, if you don't mind my saying so, for the reason that my Lord just given. Because you're absolutely right. The inter partes hearing, everything's up for grabs, if I can put it that way. So Lord Justice Males was exercising the relevant discretion afresh. It was a new discretion. So the idea somehow he was within the tram lines, whatever they were, of the material before Mr. Justice Teare doesn't seem to me to work.
Can you
Anyway.
just give me a moment? Lawrence?
Yeah.
Well, I think I made the point that we're not talking about just the material that was before Mr. Justice Teare. It's the material can go in after the event. It's the timing of the order, which is the order that, of course, starts the whole thing rolling, which is the order by which he gives permission to enforce. That's not a de novo application when we are in front of Mr. Justice or Lord Justice Males.
Right now, you've
Right.
got about 4 minutes.
Yeah, I want to deal with the power to dispense with service, which I
Yes.
think I need to deal with if I can. The first point, my lords, is that it's always been recognised, as far as I understand it, that section 12.1 of assuming, this is on the basis that we're assuming section 12.1 applies, 12.1 of the State Immunity Act applies, it is accepted that it is a mandatory provision. And indeed that's why they cannot apply for alternative service. It's mandatory in its terms. It's in both subsection 1 and subsection 2. And the point that troubled certainly Lord Justice Males at the outset was that, well, if you concede, as they have done on the other side, that you cannot have an order for alternative service, why should you be able to have an order dispensing with service in the light of section 12.1 applying? Because the one is more draconian than the other, i.e. the dispensing with service is far more draconian than alternative service. And the fact is that as soon as section 12.1 applies, you cannot evade the mandatory provision that is provided for there by the device that Andrew Henshaw QC adopted at the outset by saying, oh, well, with some clever thought we can say, oh, well, we don't actually, you can't get around that provision by saying, well, if I dispense with the need for service, then there is no requirement for service. The problem is that section 12.1 already applies. Section 1 kicks in, and it's answered in my learned friend's skeleton, his own skeleton, because he talks about we accept if section 12.1 prima facie applies, and he says if section 12.1 no longer applies because you exercise your power to dispense with service, that all is predicated on the basis that section 12.1 has applied already.
What's it applied to? In this case?
In this case, it's applied to the order.
No, because the time when the order is made, let's assume for the sake of argument, the time when the order is made, and it includes an order which doesn't require service in accordance with, it doesn't require service as such at all, does it?
Well, the order.
So what's 12? What
the
is
order,
it that 12.1 is
the
bitten
order,
on?
the order granting the right to enforce has to come first. Whether it's then there's another paragraph afterwards in the order. Another. If it's that, if we're talking about such temporal times, one suspects we're getting a little bit desperate. The fact of the matter is that section 12.1 is a mandatory provision, and my learned friend has not dealt with or answered the point that Lord Justice Males makes, is that CPR 6.1 says that part 1 of CPR 6 is subject to any enactment, and any enactment includes the State Immunity Act. And that in a nutshell is a pretty short point, and it's an answer. 6.1 says this part applies to the service of documents except where any other enactment makes different provision. Now section 12.1 makes a very clear provision, assuming that the order falls within it, that it is required to be served. You cannot bootstrap yourself up by saying, oh, well, I can look to a provision of the CPR that enables me to dispense with the need for service to take you out of section 12.1. Because then the mandatory nature of section 12.1 becomes completely illusory, and you lose all the safeguards that are supposed to be there by what we would say is a device which would give rise to a very, very large exception to section 12.1, an exception which is not stipulated for in section 12 at all. And your lordships will be aware that section 12 subsection 6 provides us with the only exception to its application, where it says subsection 1 above does not prevent the service of a writ or other document in any manner to which the state has agreed. So that requires the state's agreement and consent to take it outside.
Where are you reading from there?
It's section 12 subsection 6, my lord.
So the state can agree to dispense with service.
It can do. And basically, for the reasons that Lord Justice Males has made clear, and I think also, and I won't repeat it now, but paragraph 46 is where he sets out the further reasons as to why this is the case. It has to be right that section 12.1 is mandatory in nature, and it cannot be evaded by reference to subsequent provisions of the CPR, which are expressly made subject to the State Immunity Act provisions. It's not the other way round, as my learned friend would have us have it. Now, my lords, I see I'm 1 minute over.
Well, you haven't dealt at all with the convention.
My lord, the convention, I haven't dealt with it because in my submission the convention is a neutral point. It perhaps doesn't assist either party either way. We rely
I haven't looked it out, but there was a case that Lord Justice Leggett and I did just before Easter involving another government and security for costs, and we were shown the convention. And my recollection is that the point that you just made was accepted. I think certainly the conclusion we reached.
Yeah.
It didn't actually help one way or the other.
I think we both looked at it and thought that there may be something in there, but I don't think it actually takes the debate that much further when you are looking.
And the Act itself doesn't purport to bring the convention into effect, other than in relation to judgments in other member states against the United Kingdom.
It's the genesis.
Section 18 and 19.
It's the genesis, but it doesn't necessarily
I
assist.
don't run into all the time. I need to understand this. The way you've put this point is to rely upon the terms of CPR 6.1 and the exception. I was trying to see in my earlier exchanges with you whether it wasn't part of your case that the answer is to be found in 62 on this analysis, that in a case where a claim form is required to be served, obviously the very nature of the fact that you require it to be served means you're not going to dispense with service, as you would hold it. And you accept that would be bringing somebody before the court of constitutional proceedings. In a case where that doesn't apply, because the court hasn't required the claim form to be served, we're then into your argument about the effect of the order. And what I was seeking to put you was, well, I got your point about 62.8, 62.188, and the earlier provision, 6.44, providing a background for the purpose of interpretation of section 12.1. But if you are wrong on that, I was then putting to you another point, which was that if you look at 62.18.8.7, the first thing is that is mandatory. It says an order giving permission must be served on the defendant by. So ignore 12. That's a mandatory provision, and you don't seem to have addressed. You seem to sort of sideline. And then I put to you that taking your point on 8b, as if the order were an arbitration claim form, that really what you, on this footing, you're able to rely upon the rules themselves to say there's a mandatory provision for service. The mandatory provision for service is that it's to be served as if it were an arbitration claim form, and then it turns out we look at 6.44 to see how that's done. Now, I'm not. You've emphasised the mandatory requirements of 12.1, but you're not emphasising now the mandatory requirements, if you're on everything else, on 62.18.7. Do you not rely on that?
Well, I do, my lord,
I don't think
But
it's a bad
but
point,
it's
to an extent.
the problem is that when one gets to section 12, you are in. It's mandatory in its terms, and we're able to say, well, it's not governed by the powers to dispense with service. I 16.
I know, but I'm trying to cut. So I know I understand all that, Joe, but isn't it an argument for you to say, even if 62.12 is, as the heading indicates, purely procedural, it's headed procedure. So you might say, the other side might say, well, if it's purely procedural, you can dispense with service. Look at the other procedures, but then I would have thought you would have come back and said, oh no, in this particular case, you can't dispense with service because you're required under 62.18 you have to serve in a particular way and it's mandatory.
The difficulty is that 62.18 covers everything, not just awards against states. And undoubtedly the power under 62.18.7 is subject to 628.
I mean, much as I'd like to jump on the bandwagon of your lordship's point, I'm hesitant to do so because of that, because the scheme of part 6 is such as to make it subject. 6.1 makes it subject to any other enactment, which is where I bring the State Immunity Act.
Yes, I've got that.
But if we lose the State Immunity Act point, then I'm afraid I then am being governed by 616 and
Your entire argument, whether it's right or wrong, it must depend, mustn't it, on section 12 of the State Immunity Act being mandatory as regards service.
Yes. Well,
If you're wrong about that, then none of the other provisions in the rules are going to help.
no, you're quite right, my lord. And then we're into my respondent's notice.
Yeah.
Yes. And that's why we said it, I think at the outset of our skeleton, this is really there's one big question. Is section 12 mandatory with regard to the order of Mr. Justice Teare?
So you say 62.18.7 is subject to earlier dispensing provisions.
Well,
Well, it must be in relation to defendants who aren't states. Because otherwise you've got a situation where you have to serve, you must serve an order in circumstances where other sorts of orders wouldn't have to be served, because you could dispense with service under 628.
I'm afraid, my lord, I think that's right. Much as I hate to concede any.
I hate to agree with you.
And that's because
Unless I'm prodded from
and the
behind.
dispensing provision is where?
It-
628.
It's 628, and then
Except 6.28 applies.
It would be 628, wouldn't it, because it's not a claim form.
which is
Can I just press you on that? I mean, my lord's sort of given you. Although that applies on the face of it in all cases, you still have to read it together with the provisions of you have to read together with 6.44, which has a specific provision dealing with service on the state.
yes,
Yeah.
So,
Yes.
I mean,
my lord, very, very much so.
so we don't do a debate on the bench, but I just want to make sure that I fully understand this. But you're not contending that the combination of 6.44, which you would address 6.443, read in the context of section 12, which reflects section 12.5, when read together with 62.18.8, is nonetheless, as a matter of procedure, still subject to 6.28. Because that's what you're saying, you appear to be saying.
Well, not. Did I hear your lordship say if the State Immunity Act applied as well?
No.
No.
So I'm assuming the state immunity doesn't apply, but it's there.
Absent that,
It's absent that, but on the other hand, 6.443 reflects what's there.
yes. And the point I made in front, and this is just Lord Justice Mills, and I make to your lordships, is that if you get to that stage, that you forget the State Immunity Act point, and so you are looking at the issue of whether it's appropriate that that 628 should apply, you have to bear in mind what those provisions say and the fact that they do purport to be mandatory. And we say that Lord Justice Mayles failed to give effect to that when he came to make his decision.
So at this point, you're saying, yes, yes, 6.28 does apply, but you have to bear in mind in deciding how to exercise your discretion that it requires exceptional circumstances. That's where you bring that in.
Yeah.
Is that right?
Yes.
So you don't say it's mandatory in the sense that there can be no exception from it, but you say that if you read the thing as a whole, it's not simply a free discretion that the judge has. It's something which can only be exercised in exceptional circumstances. That's where it comes into your analysis.
My Lord, I would say that
Is
it's
that right?
Yes, it is, my Lord. I would say it was mandatory, but I'm sure Lord Justice Flaux would say that I'm wrong to say that. But your Lordship has
No,
it
no.
right.
I was addressing 62. What I was asking you about was 62.18.7,
Yes.
and I think you accept that doesn't.
Well, not on its own, but I think you're saying you look at 62.18.7, 62.18.8, you read it together with 66.4,
Yes.
and you read it against the background of the Act,
Yes.
and that's what informs your discretion.
Yes, my Lord, yes.
That's the way it comes in.
Indeed. And that's where I say that Lord Justice Mayles went wrong in this case.
I now understand that analysis. Thank you very much. Any questions? No. Any questions? No. Thank you very much indeed. I'm sorry we cut you short, but I'll allow you to go on for 5 minutes beyond past.
I'm obliged. Can I first of all deal with some points on 62.18 and specifically the argument about whether where you've had an ex parte process and then an order made, whether the order is or is not required to be served for instituting proceedings. One of the questions that was asked was, is it irrational that one might then end up in a situation where safeguards under the Act would exist if the court had required the arbitration claim form to be served, because then you'd have a document required to be served for instituting proceedings, and yet, on our case, in circumstances where it's been dealt with ex parte and all you've ended up with is an order and the order doesn't institute proceedings, therefore the safeguards don't apply. So the question is it irrational to make that distinction? Our answer to that is, no, it's not irrational. The whole point is that under the CPR 62.18 machinery, you have a process for a summary process for enforcement of arbitral awards, and that indeed was to give effect to a very important policy that I mentioned this morning about the speedy and efficient enforcement of awards. And in this sort of situation, it is to be expected that that kind of process might well be thought by Parliament to be deserving or entitled to less protections and safeguards and delay and so on than some other kind of process which would require documents to be served for instituting proceedings. So we say it's not irrational at all. It is very much part and parcel of what one would expect to find where one is dealing with this summary process for the enforcement of arbitral awards. The second point we make is, well, in a sense, the rules are what the rules are, and the legislation is what the legislation is. We say it's not irrational, but actually the real question is what is meant by required to be served for instituting proceedings in any particular case. And if you look at the particular rules in a particular scenario and they don't require a document to be served for instituting proceedings, then the answer is there isn't one and Section 12 doesn't apply. And we have to bear in mind here we submit all of this only exists in the context of procedure. Yes, it's procedure against states, but you are talking about procedure. The substantive immunity is already something that's been taken away by the will of Parliament. My Lord, at this point, can I then go back to the question that was raised this morning about the architecture, because it was something that you raised. What we have done to make the position complete, I hope, or as complete as possible, is to dig out over the shorter German. Can I hand this up to your Lordships? Thank you. We from the Middle Temple Library, we weren't able to find the 77 or 78 white book, RSC, but we have the 76 version. And so I'm hoping that when your Lordships have seen this, we will then have what are in effect the three pieces of the architecture and let me just identify them. First of all, pre-1978, which is what I've just handed up to your lordships. Second of all, 1978, which was the one I showed you this morning that was introduced by statutory instrument. Yeah. And then third of all, the CPR with 62.18. And so just looking at this, what your lordships have here is actually Order 71 of the RSC and also Order 73. And the reason for that is Order 71 deals with judgments, foreign judgments. Order 73 deals with arbitration proceedings. But the reason for having both, as you'll see in a moment, the provisions in Order 73 relating to arbitration provisions actually take you back to Order 71. So the two are interlinked. Can I start with Order 73, which is at page 1125? And you can see from rule number 1 that, first of all, it tells you that if you're dealing with an application to the High Court under Part 1 of the Arbitration Act 1950, it shouldn't be assigned to the Chancery Division. The reason I show you that is because, just to inform you, that Part 1 of the Arbitration Act 1950 included Section 26. Section 26 is the section concerned with enforcement of arbitral awards. So that would be the relevant section. Then if you look at Rule 3 over the page, that tells you that that the jurisdiction of the High Court would be exercised by a judge in chambers, master of the Admiralty Registrar. And then in subparagraph 3 it tells you no appearance need to be entered to an originating summons by which an application under the said Act of 1950 is made. So just pausing there, that doesn't tell you everything. It tells you you don't need, you didn't require even then an appearance. What it doesn't tell you is whether the originating summons had to be served in the first place, even though an appearance wasn't required, because it doesn't tell you was it an ex parte originating summons or an ordinary originating summons, but it does tell you no appearance was needed. And then if you'd be kind enough to look at Rule 8, what that tells you is that where you're dealing with an award in an arbitration that was in a foreign country that was part of Her Majesty's dominions or a territory to which the 1933 Act applied, and we've set out actually in paragraph 23 of our skeleton, which I won't go to now, which additional countries that is. So it's quite a lot of countries when you add in Her Majesty's dominions and the additional countries that were brought in by the 1933 Act. In those cases, if we're dealing with an arbitral award from one of those places, it says, if the award has, in pursuance of the law in force in the place where it was made, become enforceable in the same manner as a judgment given by a court in that place, Order 71 shall apply in relation to the award as it applies in relation to a judgment given by that court, subject to some modifications. So what this is doing is saying, if you're dealing with an award rendered in one of those countries, and it would be enforceable in that country as a judgment, then when you come here to enforce it, you actually follow the procedure in Order 71 in relation to the award. And then Order 71, going back to that at the beginning of this, if your Lordship looks at Order 71, page 1104, you've got in Rule 2 an application for registration under either of those two acts, and it tells you may be made ex parte, but the court hearing the application may direct a summons to be issued. If the court directs a summons to be issued, the summons shall be an originating summons. No appearance need to be entered to an originating summons under the rule. And then if you look at Rule 5, at page 1106, it tells you that an order giving leave to register a judgment must be drawn up or by on behalf of the judgment creditor, except where the order is made on summons. No such order need be served on the judgment debtor. So you don't actually even have to serve the order, but then if you look at Rule 7 over the page 1107, what you have to serve is a notice of registration of the judgment on the judgment debtor. That's in 7.1. And then Rule 9, at the foot of the page, provides that an application to set aside the registration of a judgment must be made by summons supported by affidavit. So that's what the rules provided then. And my lord, the statutory instrument this morning that I showed you was Order 73, Rule 10. What that did was add in to Order 73 that you have at the back here an additional paragraph, i.e. paragraph 10. So that was added in, if you like, to what you find here, which stops at paragraph 9. So what that shows, your lordships, and why this is helpful for my argument, what that shows, your lordships, is that even as at the date of the State Immunity Act in 1978, in relation to awards rendered in a country covered by one or other of those two acts, in terms of enforcing that award in this jurisdiction, the procedure in Order 71 would apply, and that had an ex parte process very similar to the Order 62.18 process, where you would not have to serve the originating document. You would then have an order made in your favour. In fact, as it stood then, you wouldn't even have to serve the order, but you would then have to serve notice of registration of either the judgment or the award. So that shows you that that kind of process, which then became the CPR 62.18, was already in play. And as I've already submitted this morning, you then had the additional Order 73 Rule 10, which was laid, I think it was actually made on the 24th of July 1978, as I said this morning. It didn't actually come into force until a couple of months thereafter, but it was already published and made just 4 days after the royal assent of the 1978 Act. If you just to complete the picture, one thing I would add as well is that if you were interested in the architecture in relation to the CPR, there is a footnote in our skeleton, footnote 4, which does actually, it doesn't obviously set out all the provisions, but it does tell you how 62.18 in the CPR evolved from the first time that it was introduced in 1999, what the different provisions were referred to as. But so far as we understand the position, the procedure was in materially the same form during the CPR. So my lord, that's what we say about the architecture. Very briefly, on the Norse Hydro case, which your lordships will recall was the decision of Mr. Justice Gross, I hesitate to go back to that after the time that we spent on it, but my lord, just a very few short points. First of all, the argument we run on 62.18 was not run in that case, so nothing said there can really have can really go that far, and as we already discussed today, it does seem to have been an obiter point anyway. Limited help, we therefore say. Plus, you have the decision of Mr. Justice Stanley Burnton, which is on, in effect, the same point, because in that paragraph I showed you from his judgment, he said in terms that he did not think an application to set aside an order was the same as entering an appearance. He said it's just a different process. Same goes for default judgment. The entry of a judgment in relation to a foreign judgment or indeed an award is not the same as a default judgment. So we do rely on that. In relation to the decision of Mr. Justice Hamblin in L against Y Regional Government of X, the key point in that case, as Mr. Justice Hamblin makes clear in paragraph 17 and then again in paragraph 28, is that the matter he was dealing with was an arbitration claim form that by the rules was required to be served for instituting proceedings. And that's the difference. Whereas in our case, because he was dealing with 62.4, we're dealing with 62.18, the situation is therefore entirely different. On my learned friend's point...
Why was it required to be served?
That's because it was covered not by 62.18 because it wasn't dealing with enforcement of award. It was, but it was dealing with peremptory order, which is dealt with by 62.4. 62.4 says you need an arbitration claim form to start the proceedings, and you must serve it. My learned friend then prayed in aid from the reasoning in that judgment. He said, well, the reasoning that Mr. Justice Hamblin applied was that the arbitration claim form involves bringing the defendant before the court for the first time in order to participate in court proceedings for the purposes of obtaining a court order. And he said that reasoning still applies to our case, even though we're dealing with a different provision of the rules. we say that's not right. The order of Mr. Justice Teare did not require the state to come to the court for the first time to participate in court proceedings for the purposes of obtaining an order. The order was already obtained. What the order did was give the state a period of time in which it had the right to apply to the court to set aside that order. And that is not the same as the analysis that Mr. Justice Hamblin put forward in the case that he was concerned with. Can I deal with a point that was raised?
Just before you leave that,
Yes, of course.
why does the thinking behind what Mr. Justice Hamblin said not apply here? I quite understand that if the claim form had to be served, it really goes without saying that that is what impedes the defendant or constitutes the institution of proceedings. But calling the defendant before the court for the first time in a case where the arbitration claim form does not have to be served is effectively done, as the judge, Lord Justice Mayles, decided, when you serve the permission to enforce.
Well, I see that, my lord, but it is different. What you're doing in the case of the order, such as Mr. Justice Teare's order in this case, is you're giving to the state an opportunity, a right to come to the court to set aside an order that's already been made. It's already been made by a summary process because that's the whole purpose of giving effect to quick enforcement of awards. So the state can come along and apply to set aside, and it has the right to do that. But that's it. It's not being required there is nothing that is required to be served on it to institute proceedings. The proceedings have been on foot for a month in this case. The court has already...
The state doesn't know that.
The state doesn't know that because the order's been made ex parte, but the question is what instituted the proceedings? The question isn't when did the state find out about those instituted proceedings. The question is what was required to be served for instituting proceedings. When you have this kind of process, the answer we submit is clear. The judge accepted as a matter of procedural law that proceedings were instituted upon the issue of the arbitration claim form. Very hard to see how, when an order is then made a month later and you have to serve that on the state, that can be for instituting proceedings. It's very, very difficult to see how that can be right. And we say, whilst that may be a narrow point, nonetheless, it's what the legislation provides for. There's perfectly good reasons why one would...
So the same thing if the claim form and the application to and the order to enforce the judgment were issued on the same day.
Well, yes, I would say the same thing. It's not for the purposes of instituting the proceedings. It's not required.
I'm having a bit of difficulty with it.
Well, it's
the reality of proceedings being instituted is, as Mr. Justice Hamblin rather indicates, when you notify, to use a neutral word, the defendant.
Well,
now, of course, we know that you can institute proceedings, then put them in a drawer and forget about them for 4 months in the case of a foreign defendant. But if a statute is talking about the institution of proceedings, is it really meaning just that ex parte thing which you do without any reference to the defendant? Because it seems very odd in the case of a foreign state in particular that you can do whatever you wish to without notifying the state, and then because you decide to notify the state at a later date or even on the same date by giving the state the permission to enforce as a judgment document, that isn't when the proceedings are sensibly, commercially, effectively instituted.
well, my lord, I see that, but actually, leaving aside 62.18 and the special situation dealt with there, it is the case that the rules make it very clear that it is the issue, not the service, but even in the standard ordinary claim form writ type case, Part 7 case, it's the issue of a claim form that starts the proceedings. That's the rules, and that's because there are real things that happen from that point in time. For example, the stopping of limitation periods, and indeed, if a claim, there are rules that provide for if a claim has been issued but not served and you come to find out about it, you can apply to the court to get it served and so on. So things do happen from that moment in time. And certainly when you translate that into the context of 62.18, the whole point is this procedure works by, the essence of this procedure is that the court makes a substantive order before anything else happens. That's what the court does. You don't need service for that to happen. So the essence of the procedure is that the institution and indeed progress to final remedy, or at least to remedy, to the relief, happens before service. And that is the essence of the procedure, designed to speed up the enforcement of arbitral awards. So we
Just awards, it's his judgments as well.
my lord, yes.
So
And
you
that's-
say that the whole thrust of Section 12 is deliberately to encourage enforcement of judgments and awards.
Well, certainly awards, because, as your lordship knows, and I made the point, Section 9, dealing with arbitration exception from immunity, was deliberately extended to include enforcement.
Yeah.
That was a very real live issue. I put the point less strongly in relation to judgments, because I think I said this morning, yes, it's true, there was already the 1920 and 1933 Act, but it wasn't until 1982 that you then had this specific provision coming in Section 31 of the CJJA. My lord, can I then deal with the words as if it were a claim form, because some reliance was placed on that. Those are the words that are found in 62.
I'm sorry, now you slightly confused me. I thought I had. You now seem to be making a point that it's the issue of the it's the issue of the originating process which starts them in all cases.
My lord, yes.
But why then does Section 12.1 say any writ or other document required to be served for instituting proceedings?
No, it doesn't, does it?
It says any writ or other document required to be served for instituting proceedings. That's the wording. So the wording, you may say incorrectly, does presuppose that the drafter thought that it was the service that was needed for instituting proceedings.
Well, in some cases, you will have an originating document, such as the claim form, which will have to be served. That the document that is the originating document has to be served. So that makes sense in that type of case.
But you're saying that's not for instituting proceedings.
Well, that is
That's
the
service.
what I was saying was that is the instituting document. The instituting document is the arbitration claim form.
But the difficulty is, as my lord says, that it doesn't say any writ or other document
Required
for instituting proceedings,
Exactly.
then to be served or whatever. I mean, you're absolutely right. Part 7, I think it's 7, Rule 1, and certainly 62.3 talk about starting proceedings by issuing the relevant claim form or arbitration claim form.
My lord, yes.
So to that extent, if instituting is starting, then that's what the rules say. But there's something odd about Section 12, isn't there?
There is. It's only in your response to my lord, you've raised this conundrum, which otherwise I hadn't really alighted on, because, like as you say, the standard position is that proceedings are commenced by the issue.
Yes,
That's how
but-
you start them. And I would have thought, subject to the point you've now just, as it were, raised in answer to my lord, I would have been disposed to accept that it's by the issue of the claim form that the proceedings are commenced. There's a separate issue about the proper interpretation in this context of instituting, but I'm not quite sure. The word's got slightly muddied here, but we can sort that out later on.
Well, in my submission, it isn't difficult, because if you're talking about the claim form that has instituted the proceedings, and that's the document you have to serve, then there's no difficulty. That is what the words mean. What this is clearly not doing is saying that every time you start proceedings, you must serve a document. And it could have said that, but it didn't say that.
And I think the language, it may be just loose. What it should say is any writ or other document for instituting proceedings which is required to be served shall be served.
Yeah.
That's what it should say, but it's compressed. The draft has compressed two different concepts, which is institution and service.
Well, that's right, my lord, and we pray that in aid because we say there are two conditions to be satisfied there. That's what. Yes, indeed. My lord, can I just say something about 62.188B, because that was quite some reliance was placed on that, which is the one that says when you're serving the order, it has to be in accordance with rules 6.40 to 6.46, as if the order were an arbitration claim form. Now, we say that doesn't assist, my learned friend, that's simply telling you, as a practical matter, how you serve the claim form, how you serve the order. And so, for example, it tells you that although it's not actually a claim form, it tells you that you can utilise 6.44 by way of example if you're serving on a state. So it's a practical matter. What it doesn't do is tell you that the order is a claim form or is a document required to be served for instituting proceedings. We say that's not right at all. And indeed, on the contrary, we would look at it the other way round. This is making it clear. The starting point is that this rule recognises it's not a claim form. It's not a claim form or anything similar.
No.
And what it's telling you is, nonetheless, you can utilise certain service provisions under Rule 6 as if it were. So we say, if anything, this goes against my learned friend's argument and in favour of our argument for that very reason. That
Well,
it's
it avoids the point that I put to Mr. Davis, which is if it didn't say as if the order were an arbitration claim form, some bright spark would come along and say, well, you can't actually apply 640.
because it only applies to
It only applies to claim form.
Indeed, and that's why we say it's to be used as a practical matter. And we would also make the point, as I think has been accepted now, that 6.44 does give way to 6.28. In other words, once you're in, if my learned friend is wrong that section 12 is mandatory and you're into the territory of just serving the order in accordance with 6.44, that does give way to 6.28 if there are appropriate circumstances to dispense. Can I then move on to the power to dispense? And I know that I'm running out of time and I'll be as quick as I can. First of all, just so this is now on the other point about is the power to dispense with service. My learned friend says, well, if it's right that you can't have an order for alternative service, why is it that you can have an order dispensing with service? And the answer to that, we submit, is the language of the primary legislation. The language of section 12.1 enables the power to dispense with service to be operated, and that's because it carries with it this concept of required to be served. And if the court dispenses with service, then there isn't something required to be served. And we say that that's the point. Now, my learned friend says, well, since section 12, he says, applies from the outset, then surely you never get into the possibility of dispensing. And we say, again, that's not the right way to look at it. Section 12 tells you you only have to serve if it's a document required to be served. The question has to be asked and answered, is it a document required to be served? If the court dispenses, then the answer is, no, it's not a document that's required to be served. And we say that is Mr. Henshaw's analysis, and it is indeed the right analysis in our respectful submission. My learned friend prays in aid CPR 6.1, which is the provision that says Part 1 of the CPR, or Part 1 of CPR 6 is subject to any other enactment, and we don't suggest otherwise. This doesn't assist him. We don't suggest that the CPR overrides the Act. It's the Act that says you must look to the procedural law to see what is or is not required to be served. The Act gives way, if you like, to the procedural law on that question, or it gives the right to answer that question to the procedural law. And if the procedural law allows for dispensing, which it does, then we submit that's the end of the matter. And my lord, my learned friend's submissions ultimately come down to, as he accepts the proposition that section 12 is mandatory and therefore you can't dispense, we submit that when you look at the wording of section 12.1 and you take into account the policy of the Act, the restrictive sovereign immunity policy, and all the other factors that I relied on this morning, we say that is not right. It's not mandatory in all cases. It's only mandatory where it applies, and it doesn't apply in all cases. My Lord, in relation to the, that's all I wanted to say on the appeal arguments. On the respondent's notice arguments, my learned friend says, well, first of all, he says that the case was, even if there is a power to dispense, you're still in the realms of Section 12. We say that's not particularly helpful to talk about the realms. You're either in Section 12 or you're not in Section 12. The second point he referred to was a laissez-faire. You don't take a laissez-faire approach. Well, that may be right, but of course, if your Lordship look at both the judgment of Miss Justice Teare and judgment of Lord Justice Mells, neither of them took a laissez-faire approach. They very carefully evaluated and analysed all of the evidence that was before the court. There was no hint of any kind of we'll just let this go through on the nod type attitude. On the contrary, my friend says, well, no attempts had actually been made to serve through the diplomatic channel. That is correct, but in the circumstances of this case, unsurprising. We say that's no bar. The judge rightly held in our submission that that is no bar. It's a question of weighing and evaluating all of the different factors. There was evidence, my friend said there's nothing in writing from the FCO, but there was evidence before the court based on conversations that those instructing me had with the FCO, in which the FCO had said it was dangerous, it was not straightforward, and it may not be possible at all. So it is certainly the case that that evidence was before the court. And ultimately, really what my Levin's submission seemed to come down to in particular was this timing point, this issue of whether it was right for the learned judge to look at things that had happened since the time of Mr. Justice Teare's judgment. Well, on that, the critical point is that even if the test is the test that my learned friend suggested by parity of reasoning with permission to serve out the Lord Hoffman test, it doesn't matter because everything that Lord Justice Mells relied on post the hearing in front of Mr. Justice Teare would fall within Lord Hoffman's analysis because it shed light on precisely the factors that were already before the court at the time of the hearing of Mr. Justice Teare. In particular, the evidence before Mr. Justice Teare, which included a very detailed 100-page, I think, congressional report about the state in Libya, made it clear that there was a near anarchy, terrible fighting, dangerous situation. Normal diplomatic operations couldn't take place. The US embassy had already been shut down, and so on and so on. The fact that Lord Justice Mells was then able to say, well, since the date of Miss Justice Teare's hearing and today, there has been terrible fighting and hundreds of people have been killed in Tripoli, which is something he did say, sheds light on the fact that what was already before the court in front of Mr. Justice Teare was indeed, very sadly, borne out by the events that had then taken place. So there isn't any tension here, there isn't any difficulty. Whether it was a fresh discretion or not, it doesn't matter. And if you look at what Lord Justice Mells said about this aspect of things, he actually concluded first that Mr. Justice Teare was right on the material before him, and he said, anyway, it was confirmed, the fact that he was right was confirmed by the subsequent material, which effectively shed light on the earlier position, which we submit was absolutely the right analysis. So those are our submissions.
Thank you very much. We're extremely grateful to both counsel and to those supporting and assisting them. We will consider our judgments in this matter in the usual way when you receive the draft judgment or judgments. Please agree to form of order. No further submissions except in writing. Thank you both very much.
All right.